One of the tricky parts of Texas law is that terms used commonly among the public have very specific legal meanings. One term which a layman might use interchangeably with other terms like ticket and citation is the term summons. In Code of Criminal Procedure terms, a summons has a very specific meaning and can't be used interchangeably with the terms ticket or citation, like you would get for speeding. In Code of Criminal Procedure terms, a summons is a legal writ that a magistrate may issue instead of a warrant. An arrest warrant and a summons are very similar. An arrest warrant is issued by a magistrate and commands a peace officer to go get a defendant and bring him or her to the magistrate. A summons is also issued by a magistrate, but instead of commanding the peace officer to go get a defendant, the summons is sent to the defendant and commands them to bring themselves before the magistrate. A summons and a warrant perform the same function, but in the case of a summons, the defendant gets to avoid the arrest process of being put in handcuffs, transported and held in jail with or without bond, and is trusted to bring themselves to court. Summons are not typically issued in Texas. According to the Code of Criminal Procedure, a magistrate may either issue a warrant of arrest or a summons in any lawful case when he can verbally order an arrest, when a person claims another has committed some offense under oath, or in any case in the Code of Criminal Procedure when specially authorized. A summons may be issued in any case when a warrant may be issued. The summons shall contain the same requisites of a warrant, except it shall summon the defendant to appear before a magistrate at a specific date, time, and place. A summons shall be served by delivering a copy to the defendant personally, leaving it at his dwelling or usual place of abode with some person of suitable age and discretion who lives there, or mailing it to the defendant's last known address. The Code of Criminal Procedure states, a warrant shall then be issued if the defendant fails to appear for a summons. Closed-circuit television cameras may be used when a defendant appears on a warrant or summons, and a recording of the proceedings must be made. The recording must be saved until the defendant is found not guilty or until appeals have been exhausted. The defendant is permitted a copy of the recording for a reasonable fee. A warrant of arrest issued or forwarded by any county or district clerk or by any magistrate, except mayors of a city or town, shall extend to any part of the state. Any peace officer is authorized to execute it in any county in Texas. So keep in mind, an earlier section of the Code of Criminal Procedure states that mayors and recorders of cities and towns are considered magistrates. Since they are magistrates, mayors and recorders may issue arrest warrants, but according to the CCP, they are only valid in the county where the city is located, except under certain circumstances. When a warrant of arrest is issued by a mayor of a city or town, it cannot be executed in a county other than the one in which it was issued unless it is endorsed by a judge of a court of record, in which case it may be executed anywhere in the state, or it is endorsed by a magistrate in the county in which the accused is found. So, a warrant signed by a mayor or a city recorder may only be executed outside the county where the city is located if either the warrant is endorsed by any judge of a court of record, essentially countersigned by a judge who has a court reporter in the county, or countersigned by a magistrate in the county where the accused is found. The endorsements may be either let this warrant be executed in the county of, or let this warrant be executed in any county of the state of Texas.